Thank you, Your Honor. If it please the court, we're before the court this morning in the matter of the State of Ohio versus Margaret Kotkowski, case number 24-CR-068. The defendant is present in the courtroom, her attorney, Nicolette Tomaszek. We're before the court this morning for purposes of sentencing the defendant having pleaded guilty and been found guilty of 1 count F5 possession of cocaine, 1 count F5 possession of fentanyl-related compound, and 1 count F5 possession of drugs. Parties are ready to go forward, Your Honor.
Ms. Thomas, is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We would just like to ask the court today for any leniency in sentencing for Ms. Kotkowski. Your Honor, with Ms. Kotkowski, I've had an opportunity not only to speak with her, but also one of her very close family members. She does have a good support system, Your Honor. Ms. Kotkowski does have a history of drug use. She has been using drugs since she was a teenager. She has done some treatment in the past, Your Honor. I don't have confirmation whether that's been completed or not. She did have an opportunity in Cuyahoga County to attempt for intervention in lieu. She was in the CBCF there actively participating. However, due to some medical issues, they did release her from the CBCF and did terminate her probation there, Your Honor. In speaking with Ms. Kotkowski, it's clear she does have some mental health issues, Your Honor. It's from the start of this case to now, it did take some time for her to fully trust me, be able to talk to me and give her perspective, Your Honor. So we'd just like to ask for any leniency in sentencing. It is clear that Ms. Kotkowski does need help, especially with her drug use, but also for her mental health issues. Our office has attempted to get her set up either at ORCA or some other facility, but unfortunately we were unable to complete that process, Your Honor. So like I said, we just asked the court for any leniency today. Thank you.
Ms. Kotkowski, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I've just asked the same thing for any leniency.
Why do you deserve leniency? I tried to give you leniency. We were here a couple weeks ago, and I continued it to try to get you help, and you refused to talk or meet with anybody. So my hands are tied right now. Well, why do you deserve leniency if you're not even willing to meet with somebody to talk to them to try to figure out what kind of help I can give you?
I've just been struggling with my mental health, Your Honor, and
that's why people were trying to meet with you to get you help for that. And you refused to meet with people multiple times. You got to give problems this morning. That's why you're sitting there with your hands cuffed behind your your back, because you were giving the COs and deputies a hard time today, refusing to even come here. I mean, these people came to see you to try to help you, to try to get you help for this mental health issues that you say you're struggling with. You wouldn't even sit down and talk with them. And it's been the history, this whole case. This happened 3 years ago because you wouldn't come to court, you wouldn't do anything. And now I'm supposed to give you leniency? You really think you deserve that? For the way this case has played out? And the way you've dealt with everybody?
I did do an assessment with Lake Geauga.
I continued the sentencing when we were here last time so that you can meet with people to try to find out the best program for you, and you wouldn't even talk to them. I mean, my hands are tied here. I got nothing more I can do. Is there anything else you want to say? Is that a no?
Or just...
We can't take up the shaking of your head, so you need to verbalize your responses.
I would just ask for a second chance.
All right. Mrs. Thomas, anything else?
No, Your
Second
Honor.
chance at what?
To do the right thing.
Which is what?
Get better.
Sorry?
Get better.
So what do you want a second chance at doing?
To get better.
Tom, is there anything else?
No, Your Honor, thank you.
Shapiro for the State of Ohio.
Thank you, Your Honor. A lot of people want the defendant to get better, but the state does not believe that the defendant is amenable to community control for some of the reasons that outlined in the pre-sentence report and as Your Honor highlighted this morning. The defendant, so the state would have to recommend prison in an amount that the court feels is appropriate. The defendant does have credit for 155 days already served.
This court has reviewed the pre-sentence report and investigation that was completed. The drug and alcohol evaluation that was completed. Consider the facts and circumstances of the offenses involved, the nature of the offenses. I've considered the entire history of this case that started in 2021. And it's been delayed because of the defendant's failing to appear for hearings. It has nothing to do with the court or the dockets or scheduling. Consider what's been said here today. All this is considered only the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, nothing stands out factually making it more or less serious. As for recidivism factors, the court finds the defendant has a history of criminal convictions, that she has failed to comply with previously imposed sanctions ordered by court. She's been on probation before. She's violated for not reporting. Multiple times. She was on probation to Cuyahoga County when this occurred. There's clearly a drug problem that relates to the offense, and she denies the problem and is refusing treatment. We've attempted to get her assessed multiple times. This was scheduled for sentencing previously. There was nothing set up for her that was going to work. I continued to provide more time to find a treatment facility that could deal with her issues, and she refused to meet with anybody. Multiple occasions. Attorney, the social worker went over to try to talk with her, and she wouldn't talk with them. So she's refusing any help. She failed to appear for court hearings in this case. As I alluded to, the offense was committed back in 21. There was a warrant issued out of municipal court on the initial case that was out for a while. This case, she failed to appear for her trial. No factors indicate recidivism is less likely. Under 29-13B1, the court notes the defendant was on probation at the time to our community control sanctions at Cuyahoga. She violated her bond in this case by failing to appear for court hearings. And there's no way the court can make any findings she's amenable to community control sanctions when she won't even meet with people and talk with them to try to get help. So I'm telling her, I want to give you help, and she won't even talk with anyone to get it. She just wants to do things her way. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on counts 1, 2, and 3. Defendants are term in prison of 9 months on each count, one of them concurrent. She has credit for 155 days she's served. And forfeit the contraband and instrumentalities. Need to advise you upon your release. You may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence here today. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The defendants award the penal costs. Do not release any, don't put anything about bond. Bond was previously forfeited, I believe, so I don't want any confusion created down there with that. I think that covers everything, Mr. DePiro. Anything else for the record?
No, Your Honor.
Ms. Tomazik?
No, Your Honor, thank you.
State of Ohio versus Adam Kane on case number 25 CR 1196, and the defendant is in court represented by counsel William Watson. We are here today for purposes of a change of plea. It is my understanding the defendant is going to withdraw his previously entered plea of not guilty and plead guilty to the state's offer, which is count 2, grand theft of a motor vehicle, a felony of the 4th degree, and count 5, receiving stolen property, a felony of the 5th degree. In regards to sentencing, there is no agreement.
Mr. Watson, does that sound accurate?
Thank you, Your Honor. May it please the court, that is my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with Mr. Kane. He has indicated to me that he is prepared to enter a change of plea as just outlined by the state. First, he understands that by entering a change of plea, he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. Mr. King, does that all sound accurate to you?
Yes, Your
You were able to hear what they said?
Yes.
And that's your what you'd like to do here today?
Yes.
You indicated you're going to withdraw your previous entered plea of not guilty and plead guilty to counts 2 and 5, and I'll go over those with you to make sure you understand them. The other 3 counts would get dismissed. We will continue the sentencing to a future day to get some reports completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding, the discussion that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
47.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in English language?
No.
Can you speak up a little bit, please? I'm having a hard
sir.
time hearing you.
No.
Okay. Are you a U.S. citizen?
Yes.
Thank you. That's good. Prior to coming into court here this morning, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing? Now, you would have received a copy of this indictment. It looks like you got it sometime back in around the middle of October. That's the document that sets forth the 5 charges you're accused of committing. Do you remember getting that at some point?
Yes.
And at some point you had a chance to look that over?
Yes.
Now, in that indictment, as I said, there's 5 counts. You're pleading guilty to 2 of them. Count 2 is the first count you're pleading guilty to. And what's alleged here and what you'll be admitting to is on or about April 28th, 2025, in Wickliffe, Lake County, Ohio, that you did with purpose to deprive Gregory Brown, who was the owner of property, that being a 1998 GMC Sierra, that you knowingly obtained or exerted control over that property without the consent of Mr. Brown or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony in the 4th degree. Do you understand what you're charged with and pleading guilty to in count 2?
Yes.
Any questions for me about it?
No.
Now, in count 5, what's alleged here and what you're admitting to is on or about April 28th, 2025, in Cuyahoga County as a part of a course of criminal conduct with offenses committed in different jurisdictions, in which one of those offenses or any element of one of those offenses was committed here in Lake County, Ohio, that you did receive, retain, or dispose of certain property, being a trailer, the property of another, being Gregory Brown and or Wendy Brown, and that you knew or had reasonable cause to believe that that trailer had been obtained through the commission of a theft offense. Can I see counsel, please? We're going to take Ms. Leslie, can you put on the record what we're doing here now?
Yes, Your Honor. The state revised the plea offer after realizing that count 5 was missing a necessary element to elevate it to a felony of the 5th degree, being the value of the property. So the state revised the offer, which it was accepted by defense, to be to count 2, grand theft of a motor vehicle, and count 3, theft, a felony of the 5th degree. All the other terms of the offer are the same.
Mr. Watson, is that correct?
Yes, Your Honor. So I did discuss that not only with the prosecutor but with my client. He indicated he understood it. On the updated written plea of guilty form, where the count 5 was amended to count 3, both myself and my client initialed those changes, Your Honor.
This reflects the original agreement, correct, that it was going to be an F4 and an F5?
Yes, Your Honor.
And one count dealt with the Sierra and one count dealt with the trailer?
Yes.
Is that correct, Mr.?
That is accurate, Your Honor.
Mr. Kane, you're able to hear what the prosecutor and your lawyer just said?
Yes.
And that's what you want to do?
Yes.
All right. So I read to you count 2. I'm going to read to you count 3 now. If you have questions, make sure you understand. But count 3, what's alleged here and what you're pleading guilty to, is on or about April 28, 2025 in Wickliffe Lake County, Ohio, that you did with purpose to deprive Gregory Brown and or Wendy Brown, who was the owner of certain property being a trailer, knowingly obtained or exerted control over that property without the consent of Gregory Brown, who was the owner, or anyone else authorized to give consent. It's further alleged the value of that property was $1,000 or more, but less than $7,500, which makes this offense theft of felony of the 5th degree. Do you understand what you're charged with pleading guilty to in regards to count 3?
Yes.
Any questions about that?
No.
Now, there's 3 other counts of this indictment that are all being dismissed. Is that your understanding?
Yes.
Any questions about any of those 3 charges?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand everything, all the rights you're giving up, and you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, as each charge, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes.
Now, if we did have a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charge, and the presumption of innocence sticks with you and stays with you until the state, if at all, is ever able to meet that burden and prove you guilty. Do you understand that?
Yes.
Now, when I talk about this burden of proof, since it's a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden of proof there is in our justice system. And what that actually means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to make the state prove you guilty beyond a reasonable doubt in this case?
Yes.
Now, in order to do that, or at least try to do that, if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. He could ask them anything he wanted to, but within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand that a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 4th degree and a felony of the 5th degree. Count 2 is a felony of the 4th degree. It's the grand theft of a motor vehicle. It's punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, the theft charge in count 3 is a felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, since there's 2 separate charges here, if I impose the prison sentence, I would impose it on each count. Then as the judge, I have the discretion to run those prison terms concurrent or consecutive. Concurrent means together, serving them at the same time. Consecutive is one after the other. You'd serve the prison term on the first count, finish that, then the prison term on the next count. Understand the difference there?
Yes.
So in this case, if I give you the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term, in this case, of 30 months in prison. Do you understand that?
Yes.
Now, are you currently on probation or post-release control to any other courts or agencies?
Yes.
Which one?
Summit County.
Probation or post-release control?
Probation.
Were you on probation when this happened?
Actually, no, I don't. Not for this case, no.
Were you on probation in Summit County?
Were you on probation
Yeah.
in Summit County when the acts in this case occurred?
I don't think so. No.
Okay. I'll tell you the reason I'm asking, just so you know. If you're on probation and commit a new felony while you're on
Yeah.
probation, there can be consequences with that court
Yes,
for
I
committing
understand that,
a new
yes.
felony. Nothing I can do about it, nothing I will do about it, but
Yeah.
there could be consequences there.
Yes.
Now, if you weren't on probation at the time, then that's not the case. That's
Yeah.
that's why I asked, to make sure you understand that.
Yeah, they didn't violate me or anything, so yeah.
Right, so you're aware of that.
Yes.
Do you have any other charges pending against you right now?
No.
Okay. If a prison sentence is imposed in this case upon your release from prison, you could be placed on what we do call post-release control, sometimes called parole. It's a period of supervision you would be on after you completed the prison sentence, and in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you're on post-release control at any point, never violate any of the conditions, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from this possible prison sentence, there are other sanctions that could be ordered. You could be fined up to $5,000 on count 2, $2,500 on count 3. Altogether, it's a $7,500 possible maximum fine. If you're ordered to pay court costs, you can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes.
You can also be ordered to pay restitution if that's applicable here for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes.
Now, a few moments ago I explained the possible prison sentence. I did use the word possible because prison is not mandatory in this case. You are eligible for probation or what's called community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be granted community control? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented. Then I'll make the decision I think is the right thing to do. You understand that?
Yes.
Now, if you are put on community control, it could be for up to 5 years of supervision. And as the judge, I had the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be in order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you are on probation at any point, you ever violate any of the conditions, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison at that point. And if I did it then, again, it could be for the period of time I mentioned before, which is up to a maximum of 30 months in prison. And that could be consecutive to any other sentence you may be serving some other case or that you're being sentenced to at that time for some new case. Do you understand that?
Yes.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want me to know or consider. Your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what it says, a recommendation. I don't have to follow that if I didn't think that was the right thing to do. You understand that?
Yes.
All right. All right, well, do you have any questions for me about the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your lawyer and have him review everything with you and answer all your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen to you at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this time regarding anything we've just talked about, the rights you had that you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No.
Then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we did have a trial. I want you to listen to her because then I got some questions for you about that, all right?
Mm-hmm. Yes.
Ms. Zaleski.
Thank you, Your Honor. If this case proceeded to trial, the state would prove beyond reasonable doubt that on April 28th, 2025, in Lake County, state of Ohio, the victim, Gregory Brown, had contacted the police department to let them know that someone had stolen his truck and trailer from his business that was located right on Euclid Avenue. The defendant was observed on surveillance video around 4:30 in the morning backing up a pickup truck to the business. He parked adjacent to the building, backing up to a truck that was parked on top of a trailer adjacent to the building. There was a hitch lock on the tongue and trailer of the trailer of the vehicle, on the trailer to prevent the theft of the trailer. That was removed, and the defendant drove off with the trailer and the truck on top of the trailer. The truck and trailer were located later that day around 2:00 p.m. in Garfield Heights. Through further investigation, the defendant was identified as a suspect, and cell tower records placed the defendant in the area at the time of the offense. In August, when the defendant was arrested and interviewed, he admitted that he is an alcoholic and drug user, and that it was possible that he came to Wycliffe to steal the truck and trailer due to him being intoxicated. The value of the trailer exceeded $1,000. Thank you.
Mr. Kane, were you able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we did have a trial?
Yes.
What, if anything, did to say about those facts as she presented them? Are they true? Did you do what she said?
Yes.
Very well, then. Regarding count 2, charging with grand theft of a motor vehicle, a felony to the 4th degree, what is your plea to that count?
Guilty.
Regarding count 3, charging with theft, a felony to the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything we just talked about. Before I can accept your plea, I need to make sure you understand this document and you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this with Mr. Kane, go over it with him, answer his questions?
Yes, Your Honor. I did review the written plea of guilty form with my client. I read it to him. He read along with me, indicated he understood it, and then he signed it and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Kane?
Yes.
Do you understand what the document says?
Yes.
Any questions for me about what it says?
No.
Now, it also appears that you signed the document. Did you in fact sign it?
Yes.
And Ms. Zaleski, you witnessed that as well?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 2, grand theft of a motor vehicle, a felony of the 4th degree in violation of 2913.02A1, as well as count 3, theft, a felony of the 5th degree in violation of revised code section 2913.02A1 as well. I will defer sentencing. I'm going to order a pre-sentence report and investigation, victim impact statement, drug and alcohol evaluation.
Yes, Your Honor, please.
Drug and alcohol evaluation. And continues defendant's bond. I have an OR bond with GPS monitoring and a condition of no contact. Is that correct?
Yes, Your Honor.
All right. So what all that means at this point, Mr. Kane, as far as your bond goes, I'm continuing that, so there's nothing more you need to do, but you do need to comply with the conditions of your bond. One of those conditions, aside from what I mentioned, is in order that you don't use any drugs. That you don't use any drugs while you're in bond. You have to submit your screens. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued. Do you understand that?
Yes.
Now, this report I've ordered is necessary for me to be able to, it's done so I can learn more about you. And it's necessary to be completed in order for me to consider probation. Without a report, the law doesn't even allow me to consider probation. So it's important you show up on time when scheduled at the probation department for the purpose of that interview. If they can't interview you because of your lack of cooperating or showing up when you're supposed to, then they can't do a report. Without a report, I can't consider probation. You understand that?
Yes.
It's also important that you're open and honest with them when you talk with them, because they're going to check and verify everything you're telling them. And if they learn you're misleading them in any way, they're going to let me know that, and I certainly would consider that sentencing. You understand that?
Yes.
All right. I think that covers anything else for the record, Mr. Leshy?
No, Your Honor, thank you.
Mr. Watson.
Nothing further, Your Honor.
Thank you.